As Nicola said, my name's Juliet and I work in the corporate responsibility team at Freshfields, and we are currently working towards banning the box, and I've been asked to share some of our experiences so far. So just to give a little bit of background, our support for the Ban the Box campaign follows the firm's long-standing involvement in BITC's Ready for Work programme. We have supported the Ready for Work programme since 2001, and as part of our support we offer work experience placements to participants on the programme. In 2011, with more people being referred onto the programme with unspent convictions, we wrote a policy in consultation with the probation service and BITC that enabled us to assess participants with unspent convictions on a case-by-case basis. I think key to us being able to do this was making sure that we had buy-in from our senior people, and to begin with this was quite difficult. We had to change people's attitudes and perceptions, and we also needed to understand more about the criminal justice system, so personalising each case, looking at circumstances surrounding convictions, what steps individuals had made to move forward with their life since their conviction, and whether the conviction was really relevant to our business. And we know that by banning the box, we will be integrating our commitment to corporate responsibility with our mainstream recruitment practices. So our decision to ban the box was taken quite quickly after the campaign launched, and in fact, rather than the question being why would we do this, it was very much a question of why wouldn't we. But banning the box from the application form was the easy part of the process. It's really thinking through the policies that sit behind that decision that take longer. We're using our experience from Ready for Work and working with HR to write a recruitment policy to ensure that we take a standardised approach across our London office, and really looking at how we can communicate this change to our staff in the right way. Because this isn't about dispensing with risk. It aims to give people a clear understanding that their record won't automatically hinder their chances of getting a job. Convictions that are disclosed will be assessed on a case-by-case basis, meaning that far from ignoring the risk, we're managing it, but in a way that really helps people, helps society and helps us. Because through banning the box, we know that Freshfields are going to benefit from access to a wider, more diverse and talented pool of applicants who may otherwise have been excluded because of really what may be just a totally unrelated conviction. To be able to implement this change, it was important for us to understand what we were asking about in order to know how and when we should ask about an unspent conviction. And we've decided that we're only going to request that information once a job offer has been made, meaning that anyone with an unspent conviction will be competing on a level playing field and judged primarily on their skills and their suitability for the role. It was also crucial for us to understand any restrictions within our own industry. So our lawyers are regulated, but the majority of our business service roles aren't. And I'm sure Chris will go into more detail on this later, but just very briefly, the Rehabilitation of Offenders Act enables criminal convictions to become spent after a period of time or rehabilitation, unless the conviction is over 4 years, in which case it never becomes spent. So after this time, except in certain cases, you don't have to declare your conviction to a potential employer. However, some occupations like lawyers require all convictions to be declared, so even if they're spent, they would still need to be disclosed. But having said all of that, we hope that we're going to be able to ban the box across all our roles in the London office. We also needed to look very carefully at what was really relevant to our business, because what's relevant to a law firm may not be relevant to another business. So, for example, Timson won't hire anyone with an arson conviction, and as a law firm, there are some convictions where the risk of hiring that individual would far outweigh the benefit. So we would be unable to hire anyone with a fraud conviction. Just a little bit of information. When we kind of thought through the process and what we needed to do, there was loads of information that we were able to get from the BITC website and also on Unlock and NACRO's website. So if you are thinking of banning the box, I would really recommend that you go and take a look at some more information there. And I think finally, just before I hand back to Nicola, I'd just like to say that in banning the box, BITC aren't asking for a huge change. We're still going to be asking for the same information we would normally do, just at a later stage in the application process. And we really believe it's a step that every business can take, and we hope that if we can do it, so a stuffy old law firm can do it, we'll be able to inspire other firms to change their application process too.